On August 19, 2023, Dallas Sawyer was arrested and charged with boating under the influence of alcohol. Mr. Sawyer retained attorney Hagan, who promptly requested discovery from the state of Kansas, including lab results of a blood draw conducted at the time of arrest. As Judge Webster considers dismissing the case, ChatGPT attempts to explain what happened with the discovery.
On the record, State of Kansas versus Dallas, Kervin Sawyer. And how does your client wish to proceed today, Mr. Hagan?
Well, Your Honor, I did last time I can set it over, or we did, to get records, and I've got almost all the records except I don't have the blood results. So I'm needing those. There was a blood draw, and so I need to get those blood test results.
Well, that's understandable in light of the charge. Mr. Regier, do you have any idea where the lab is on those reports?
Your Honor, if the court is finding that the counsel for defense is making a discovery request on the record and determines that that it is appropriate to set this matter over, I will put a note in the file.
All right, but you do not. Oh, is this Mr. Sweeney's case? Voting under the influence. I do see there was an amendment. Let me double check that amendment, make sure that doesn't change anything we may do today. It's so frustrating to have this state odyssey system sometimes cooperate wonderfully and other times not as wonderfully. So we are still looking at operating a vessel under the influence. If it's based on a blood draw, as you say, counsel, and I'm sure it is based on your conversations, I think you do need those. And I'm still not sure if this is Mr. Sweeney's case, but I will set this over as this is the first control, but I am really trying to limit the controls. June 17th, 2024 at 9 a.m.
Your Honor, I've been waiting for blood tests, and I don't have them yet.
Your Honor, I've got them. At least I can find them here in the filing cabinet. I can't explain why Mr. Hagan hasn't received that yet, but I'd be happy to forward them to him.
Well, I haven't ever received them, and I've asked for
Sure.
them in the beginning, so
All right, so
I just need to get them.
all right, this will be continued August 19th.
Well, Your Honor, we've been waiting for blood tests on this case, and that's why the state has continued it. Last time we were here, they said they had them, and then they didn't send anything. So we called the office, and they said, we've already sent everything we have to you. And you'd have to do another request or something. And so anyway, I don't have blood tests, and I've been waiting for them.
Mr. Regier, is that your office's position that there are no blood tests?
Your Honor, in accordance with my duty of candor as an officer of the court, I am showing a KBI lab report in this matter.
I sure wouldn't want to find the county attorney in contempt, but yes, we have addressed that. All right, thank you, counsel. We'll be in recess till November 4th at 9. We'll now be on the record in Sawyer, State of Kansas versus Dallas, Kervin Sawyer. And how does your client wish to proceed, Mr. Hagan, on this one count of voting under the influence?
Well, Your Honor, this case has been going on for about a year.
Yes.
We still have yet to get the blood results. And we've been asking for those, and you ordered them probably the last 2 times we've been in court. And I still don't have them. My office calls, they said they've provided all the reports. And so here we are. I mean, I should make an oral motion, to dismiss this case based upon the time that this case has been going and the lack of blood results.
Mr. Regier, your response, and I know this probably isn't your case, but you're on the spot with it today.
Yes, Your Honor. This is a case where it is the state's understanding that blood draw reports and KBI lab reports were involved in this matter. I have communicated with my colleagues. It is the state's understanding that counsel for the defense's office communicated with my office back in March, and that at around that same time, both the blood draw results and the KBI lab reports were provided pursuant to standard discovery procedures, and all discovery has been provided in this case.
Well, even if that is the case, why in the world, since March, could you not have given him another set? I mean, that to me just seems like a obvious solution to this. If whether he has them, whether you sent them or not, he's saying, I don't have them, I need them.
I received all the reports, Your Honor, and there weren't any blood tests in what I received. And we've been asking for this, and they said they'd provide them.
Right. And I know people are human, and it may have accidentally been left out and not, someone didn't realize it.
And Your Honor, I did
Put in there and Mr. Hagen's staff misplaced it. I don't know, but he needs those reports. He's been asking them since, oh, I don't know, April, June, again on August, now in November. Why can we not just give him another copy, Mr. Regier, if you know the answer to that?
Your Honor, I did communicate with my colleagues regarding that this morning, and it is the state's understanding that an additional and that my office did make those available again this morning. So
All they need to do is send me the lab.
That's all they need to do. And I've told you to do that. I've told your office. And I suspect, Mr. Regier, that you've put notes in your file telling people to do that. And I just don't understand why it's still an issue. Well, Mr. Regier, is this Mr. Sweeney's case? Is it Mr. Canfield's now, or is it yours?
one moment, Your Honor. Your Honor, it would appear that unamended information was filed in this case. My name does appear to be on it. If counsel for the defense will communicate with me directly, perhaps that will enable a timely resolution to be reached in this matter.
Okay, so they put you on the case. Had you filed the amended information, or I shouldn't say they had you. You filed the amended information January 30th of 2024. And it does have your name on it. And I understand that in this business, the prosecutor doesn't personally put the paper in an envelope and mail it or fax it or whatever, but unfortunately the attorney is the one where the buck stops. So your staff is telling you they sent it in March. You don't have any indication that they tried to send another one after I ordered them to several times?
One moment, Your Honor. Your Honor, may I go off mic and off camera briefly?
Yes, if you would, please.
Thank you, Your Honor. Thank you for the court's indulgence, Your Honor.
Yes, we are back on the record now in 23 FG 3000002, State versus Dallas Sawyer, all parties as before. Mr. Regier, as you were taking care of whatever matters you needed to there, I did a little review of the file, and it looks to me like Mr. Hagen entered his appearance on this case before it was filed, in anticipation that it would be filed. Mr. Hagen entered his appearance December 27, 2023, and the charges were filed strike that. It looks like it was filed first. It was filed December 7, 2023. Mr. Hagan filed his entry of appearance 20 days later on December 27, 23. The amendment that you referred to was filed January 30th to 24. At that time, January 30th to 24, blood or breath alcohol concentration of 0.15 was alleged. The defendant made bond of 15,000 OR on January 3rd, 2024. His first appearance was April 1st of 2024. We are now to November 4th, 2024, and we are still in this deadlock of why Mr. Sawyer's attorney says he still doesn't have the reports after I've ordered him multiple hearings over the course of the year. So, Mr. Regier, what light can you shed on this situation?
Your Honor, in reviewing my notes, it would appear that I did request my staff to review this back on August 19th, and it was confirmed that the reports were provided. I also have a note in my file which would appear to indicate that the reports were successfully received by counsel for the defense's office on March 12th of this year at approximately 10:26 a.m.
And how do your notes confirm that?
In communications with my staff, Your Honor, as well as a certain ledger concerning the issue of discovery.
All right, but you don't have anything confirming from Mr. Hagan's end that he received those? Just that
Your Honor, it would appear that there is a note in my file which would appear to indicate that an email was sent out concerning the issue of discovery to counsel for the defense's office on March 12, and it was confirmed by the individual from counsel for the defense's office that the email was received.
Mr. Hagan, do you have a response to that?
Sure, Your Honor. What I received March 12th were all the reports that I know of from them, and they did not have a blood test with them. Every time we've been back to court, I've said that. And my office called and said, send the reports. They said, we've already sent them all, just like he's telling me again. And so here we are, how many months later, and all I've asked for is the lab results, and I don't have them to this date. And every time we've been to court, that's all we talked about. He said he would send them that day last time and the time before. So I'm confused.
I am too. I know both attorneys are officers of the court, and you're both very credible, responsible attorneys. And so I'm in a very difficult position, not knowing what to think, because I know that Mr. Regier is very diligent. I know that you are as well, Mr. Hagan. My suspicion, if I had to just come up with without saying someone's just not being truthful, which I don't think that's the situation at all.
No, I don't think that he's anything other than we've asked for him and I haven't got him.
That's the troubling part. That's saying, well, we sent them back in March is not satisfactory to this court. Every time I tell you to send them, I expect them to be sent, and not this, well, we've already sent them, we're not going to do it again. That is totally unacceptable. This is the defendant's right to this information. It is the defendant's entitlement to see the evidence against him, to question it, to examine it, and he is being denied the right, whether his attorney lost the documents, whether the county attorney's office in good faith thought they included them in that email but left them out. They've been told multiple times, get them there. So it's been about 210 days-ish, approximately, since first appearance in this case. And counsel, why should I not just dismiss it right now? Because I have told the county attorney's office multiple hearings now over the course of months to send him those blood reports. If he's got them, so be it. Send them again. Do you have a good answer on that, Mr. Regier? And I know you're in a tough spot here, but the buck
Your Honor, if the, Your Honor, if that is the court's order, and if the court is prepared to take a brief recess in this matter, I can communicate with my staff regarding this issue immediately.
Would you do that, please? I know we've got
Certainly.
a lot of hearings to cover today, but I know this is a big issue. 0.15 while voting, that's a big issue. So if you would, Mr. Regier, I'll certainly give you time to come up with that. Now, let's go back to Mr. Where did they go? Mr. Hagan's client. Back on the record in State of Kansas versus Dallin Curvin Sawyer. All parties appearing as before. I believe I posed at least a rhetorical question to you, Mr. Regier, as to why I shouldn't dismiss this case based on its history and certain facts. And Mr. Regier, have you a response at this time?
Your Honor, again, the state's understanding is that discovery was previously provided in this case. I have had communicated with my office further regarding this matter, and it is the state's understanding that the requested information has been provided to counsel for the defense, and counsel for the defense has confirmed receipt of the same.
Okay. Mr. Hagan, you didn't
Sure.
ask to have it dismissed. You brought up that you could or might or should, but what's your position?
Well, my position, Your Honor, is he tells me that they sent this in April. In June 17th at court, you ordered them to provide me the reports. June 17th of this year. Then we were back on August 19th. I still didn't have it. They said they would provide it. They still haven't provided it. And I don't know how he's trying to stand on what he sent me in April or whatever, because, you know, we've been to court several times. He's been ordered to do it. They said they would do it that day. And now he's trying to say, well, we already sent it, so that doesn't count. Under the statute, Your Honor, he has 180 days. And we're past the 180 days, and I don't see any excuse for him not to have provided it to me by now. So I'm requesting that the case be dismissed, Your Honor.
Mr. Regier, do you have that document in front of you?
I do, Your Honor.
Would it not have just taken a couple of seconds for the county attorney's office to fax or email that again to Mr. Hagan?
Your Honor, unfortunately, I would need the opportunity to discuss that issue with my colleagues further.
I think it's a common sense answer. You know, I could say that, yes, the county attorney sent it in March or April, and that Mr. Hagan just lost it. Worst possible scenario, Mr. Hagan is, you know, I hate to even say or suggest that the remote possibility that he's just using that as a stalling technique. But you can't even do that when I keep telling the ordering that the report be sent every 2 months. If you were telling me, yeah, we sent it every 2 months, every time you ordered it, Judge, then Mr. Hagan would kind of start looking suspicious that he either wasn't running a very efficient practice, or that he was in the habit of losing things, or worser issues. But Now, this defendant is entitled to a speedy trial. And I don't see that he's been given the speedy trial. And because I have ordered multiple times that that the alcohol and drug evaluation be turned over to the defendant, and it has only been allegedly turned over once, back before I ordered it.
And your honor,
Mr. Regier?
it is also the state's understanding that the request information has been provided to counsel via email, and I believe your honor may have been included on that same email as of this
Saying
morning.
An email of what date?
This morning at approximately 9:37 a.m., your honor.
Well, Mr. Hagan, have you seen a well, that's
Your Honor,
after the hearing started.
I've been on Zoom. I've been on Zoom since 9 o'clock this morning. If
So
he
have
said
I.
it this morning, I may have well received it, but I haven't looked for that, Your Honor. That seems to be quite late to.
Yeah, I'm not going to take the time to look at that. We've already used far more time on this case than what it should have taken. I'm very, very troubled at the thought of just summarily dismissing this without hearing the evidence. But I also have to recognize the defendant's right to a speedy trial. I'm going to hold this in abeyance before I make a decision on it. I want to do a little bit of pondering and reviewing speedy trial and so forth. Jen, do we have any time on a 1:30 before? Well, Mr. Hagan, are you available on 1:30 Wednesdays?
Which Wednesday?
Well, I don't know which Wednesday. I just want to make sure you didn't have something that kept you tied up every Wednesday.
No, I don't have it every Wednesday afternoon.
Jen, let's see if Jen can squeeze this in for
that's
review,
actually
so
a
I
good
can-
day for me. So
How soon are you wanting it, Judge?
Oh, what do you have, about 2 weeks maybe? Would that be workable?
I've got a good opening on the 20th of this month.
that's fine.
How about November 20th at 1:30, Mr. Regier?
No objection to that date at this time, your honor.
All right, so I will meet with you all again, client, Mr. Sawyer as well, on that date and time, November 20th at 1:30 to render a decision on what to do about this. In the meantime, Mr. Regier, what the heck? I'm going to order it again. Send him the report and see if there's any chance that you could talk your staff into getting it to him.
I will put it on the file, your honor.
All right. And I'm just talking about the alcohol and drug evaluation. That's all. He seems to have everything else. All right.
Very good, your honor.
Thank you.
Thank you, Your Honor.
We'll be in recess. Mr. Sawyer, you're still on bond though.
Thank you, Your Honor.
You're welcome. Okay. Well, let's take up the Sawyer matter on the record in 2023 FG 3000002, State of Kansas versus Dallas Dallas Curvin Sawyer. Jared Regier appearing for the state, the defendant in person and with counsel, Peter Hagan. The defendant is charged with voting under the influence. I believe we are here because of a matter I had taken under advisement. The defendant had requested and the court had ordered multiple times that certain evidence be provided to the defendant. And that mainly involved blood test results from the Kansas Bureau of Investigation. And I understand that every time I ordered it at each hearing, county attorney, the assistant county attorney was told by his staff that it had been provided in March or something of that sort. But in fact, it was never released and provided when I ordered it. Am I remembering this all correctly, Mr. Regier?
Your Honor, the state's understanding is that at the previous hearing, counsel for the defense had proffered an oral motion to the court for dismissal. I have had the opportunity to review this matter further, and the state would be requesting the opportunity to respond in full to the oral motion.
Mr. Hagan, do you want to just, for the record, to renew your motion?
Yes, Your Honor, we'll just renew the motion. I did not get the blood test results and I had requested them from the state. On 6/17, we were in court and I told Your Honor and the state, I still don't have the blood test. They said they would provide them and you ordered them to provide that. I believe we came back on 8/19 and I still did not have the report and requested him from his office, and they had provided us everything with our on 8/19, you ordered again the district attorney personally, as you did on 17th of June, to just give me the blood results. And I did not get them. And then on 11/1, we were here when you were taking this under advisement, and I was provided when we took a break for Mr. Regier to talk to his people about it, and he emailed me the result on that day.
So you did get the results the last hearing after the motion?
Yes.
And your position today?
Well, it's been, I believe you counted the time, Your Honor, and it's been past the 6 months that the state would have, and it's been all their, the reason that it was continued is because they didn't provide what you ordered them to provide.
Well, I know that sometimes it is difficult for the prosecutor to get certain information or evidence from specifically the Kansas Highway Patrol. And I take into consideration the efforts of the state trying to obtain those. But as I understand in this case, the state had that report that the defendant was requesting all along, but just wasn't releasing it because somebody kept saying they'd already sent it. And defense counsel kept saying, well, you may have sent it, but it didn't come with what I have. So that's why I said, it's not, don't argue about it, just do it. Just send it again. So Mr. Regier, go ahead, please.
Yes, Your Honor. As previously indicated on the record, in the interim between this hearing and the last hearing, my office did have the opportunity to research the matter further, and to that end, the state is prepared to recount the entire discovery process in this matter. To that end, my office has prepared a report detailing the entire process based off of screenshots of that using the discovery software utilized by my office, not only in this case, but in all other cases. I am prepared to share that on the screen. Would the court prefer a copy of that report be emailed to the court?
I would actually prefer screen sharing if you have that available.
I do, Your Honor, if the court will permit me.
Yes, go ahead.
One moment, please. Your Honor, is the court able to see the document on the screen?
Yes.
Thank you, Your Honor. Your Honor, if the court will respectfully direct its attention initially to the entry at the bottom of the screen, log type insert.
I see that.
Your Honor, the court will note that the updated date on that one is January 3rd of 2024. I believe that would have been prior to the hearings referred to by counsel for the defense. The state, after conferring with my colleagues, I have confirmed that is the point at which the discovery file was created. Additionally, if the court will direct its attention to the upper left-hand corner of the page, the court will note that it includes a notation stating case authorized on January 3rd of 2024. It is the state, I have confirmed that that is the point where this particular file was authorized.
Okay, you lost me there. Okay. I see the January 3rd at the bottom. And what was the other thing you referenced?
The case authorized notation in the upper left-hand corner, Your Honor,
Upper,
with the same
Oh,
date of
okay.
January 3rd of 2024.
okay, I see that now. Case authorized.
Thank you, Your Honor. Your Honor, if the court will permit me to fast forward to page 6 of the report.
Okay.
Your Honor, this is the ledger part of the same report that identifies authorized users of the discovery file. The court will note that there is one authorized user included for this, counsel for the defense with an email address on the screen, and that counsel for the defense was added as an authorized user pursuant to the date created screen on January 3rd of 2024 at approximately 1:29 p.m.
I see that.
Thank you, Your Honor. Going back to page 1 of the ledger, the court will note that above the entry labeled insert, there are a series of 5 upload entries beginning from approximately January 3rd, 2024 at 1:32 p.m. and concluding on January 3rd, 2024 at 1:39 p.m.
I see.
Among those uploads include multiple files labeled video, as well as a file labeled 23FG300002, which the court will recall corresponds with the case number for this particular case.
Noted.
And Your Honor, and fast forward to page 5 of the report. This is the contents of the discovery file as I understand it, including at least one file labeled media and another application/zip entry with that same number, 23FG300002. Both of which status dates of January 3rd, 2024.
But what is this telling me?
This, Your Honor, what I have confirmed that this is the contents of the discovery file as provided to counsel for the defense.
What is the contents? The information on the previous page or the information in this blue box?
The information on the screen right now, Your Honor, and the state would also direct the court's attention to page 8 of the report, which will show the contents of the file 23FG300002.
All right, so the page you have on the screen is showing me that something electronic was sent to defense counsel?
It is showing the contents of what was sent to defense counsel. And if the court will allow me to go to page 8, I will be able to show the court the contents of.
Well, all I'm seeing on this is name, status, date modified, modified by, and name type. Which of those tells me what defense counsel received or what was sent to him?
Your Honor, both of these were sent to defense counsel, and if the court will permit me, I can move to another screen that will show the contents of
All right,
the highlighted portion.
okay, so this doesn't really show me what was sent, but it,
Well, I never received the blood test, Your Honor, and I did
I-
a lengthy report, but those weren't in it, and that's why in June and August, the DA was ordered to give that to me. Whether it's in there and I'm supposed to go through there, I went through every page that they sent me because they sent it to me.
well, and that's the only issue is, why didn't you just give him the alcohol and drug report when I said to? But maybe you'll
You
answer
ordered it.
that.
You ordered it twice, Your Honor,
I
and I
know.
even had my office call after the first hearing, and they said, no, we've already provided you everything.
Yeah, forget what the judge says, we've already done it. So go ahead, Mr. Regier.
Thank you, Your Honor. Moving on to page 8, these will show the contents of the file 23FG 300002. Including multiple files labeled affidavit, blood draw, KBI lab, Sawyer, KSAR, and so on.
Okay, now, did you put this green highlight on there for purposes of the hearing, or would it have been like that when it went to defense counsel?
For purposes of the hearing, Your Honor.
All right, so you're telling me that if I click on that, if I had access to this and I clicked on blood draw and KBI labs, I would get what I need to know about the lab draw and the results?
Yes, Your Honor.
And you're saying that this is the same thing that defense counsel would have seen if he clicked on it?
Yes, Your Honor.
And that went, well, now this says, what's that? Why does it say 9/25/23 that it was modified? What's that got to do with the case? Had it already been done before the case was filed?
Your Honor, the date modified, as I understand it, is the date that the file was last modified. If the court will recall, going back to page 1 of the report, the insert and upload entries dated January 3rd of 2024. Those are the dates that the file was initially created and that the documents were uploaded to the file.
Okay, now let's look at those items. What is in 23 FG3, all the zeros and 2? What documents are in there?
Your Honor, going back to page 8, Your Honor, if the court will direct its attention to approximately halfway up the screen to the file browser.
Okay.
The court will see a file folder 23FG300002.zip.
Okay.
And within that, there is a reports folder.
Well, I see the word reports.
And the court will also note that in the upper left-hand corner of the window, it indicates that the browser is currently set for the reports folder.
Right.
And the documents observable to the court on this screen are the contents of that folder.
Okay.
Including the KBI, the files labeled blood draw and KBI lab Sawyer.
So this is everything that was in that entry that I asked you about.
Yes, Your Honor.
Okay, let's go back to that screen if we could.
Thank you, Your Honor. The court will also note that on page 1, there is an entry approximately a quarter of the way up the page above the upload section, log type email sent.
Log type update view email insert. Where are you?
The highlighted entries, the second highlighted entry from the bottom.
Oh, okay, email sent, okay.
And and under the updated column, in that same column, it includes counsel for the defense's email.
Mhm. Right,
And besides that, there is an updated date of January 3rd, 2024 at approximately 1:55 p.m.
okay,
Your Honor, further up on that page, there is a purple highlighted entry labeled update
I see that,
with an updated date of March 12, 2024 at approximately 9:46 a.m.
noted.
Your Honor, if the court will permit me to, forgive me, Your Honor, jump over to page 7 of the report.
Very well,
Your Honor, this is page 7 of the report is a phone entry dated March 12 of 2024 detailing a conversation between counsel for the defense and my office.
And I'm not able to read it on my screen, just so you know.
it's pretty small here too.
Does the court wish?
Why don't you read that for the benefit of both of us, Mr. Regier? I mean, I can see it, but it's pretty tiny.
I can enlarge the screen if the court wishes it.
If you can,
Forgive me, Your Honor. Is that better?
that's better, but I don't know if it's good enough for council. Can you see it? That's much better.
Forgive me, Your Honor. Experiencing a slight lag.
Okay, and this is dated 8/25/23.
Your Honor, the date is March 12th of 2024.
Oh, okay. Let me get the history. I was doing that as you were calling that up. So the case was filed 12/7/23. The entry of defense counsel's appearance was 12/27/23. This email is dated March 12th, so we'd already had defense counsel for 3 months. And his office sends out this email stating they paid the discovery fee but never received anything.
And Your Honor,
Someone in the CA's office reactivated the case and DocuShare and explained it was sent to the office on 1/3. So she or he is saying on 1/3/24, discovery was sent by DocuShare, right?
yes, Your Honor, and if the court will recall on page 1 of the report, it did refer to an email being sent on January 3rd of 2024.
Yes, I do remember all that. All right. And 3/12 defendant. So he emailed the same day discovery was sent? No, strike that. Okay, go ahead, Mr. Regier.
Thank you, Your Honor. The court will note that, again, that this record is dated March 12 of 2024. In returning to page 1 of the report, the court will note the updated entry, which is also dated that same day, March 12 of 2024.
Okay,
The note from the correspondence dated March 12 of 2024 indicates that an email should have been sent with the discovery to the attorney, and the defense counsel's office confirmed that it was received and would attempt to pull it off.
okay. And I don't think that's been the issue. They've acknowledged that they did receive a discovery file. Is that right, Mr. Hagan? You just didn't have the one document in it?
Correct.
Okay.
And Your Honor, going back to page 1 of the report, the court will now note that that while the state does acknowledge that historically their discovery has perhaps consisted of just handwritten notes saying that a disc was sent out, my office has progressed far beyond that. The court will note that the first entry on page 1 does have a log type indicating download single started.
All right.
And with being updated by counsel for the defense.
And that would be one of those two lines there. Download single successful. Is that what you're saying is?
The top highlighted line, Your Honor.
The very top line?
Yes, Your Honor.
Okay.
That specifically refers to the file 23FG300002, which would include the reports, including the KBI lab results.
Okay, so that line indicates that someone at Mr. Hagan's office actually pulled the information from the file, right?
Initiating the download process, Your Honor, and if the court will permit me to continue, I will be able to confirm for the court when that was successfully completed.
All right. Well, why don't you show me what it was he got? What can you walk me through? Was the report in video 1? Was it in video 2?
Your Honor, the report, Your Honor, on page 8 of the affidavit, the report is in the reports folder in the file 23FG300002.
Okay, but is there, show me that, okay, this black file has all this stuff in it, right? Whatever's on this black screen has all of this stuff in one file, right?
Correct, Your Honor.
Now show me how Mr. Hagan's office is going to see that when they download it.
Very good, Your Honor. Again, this top entry shows download single started. Shows that Mr. Hagan's office did commence download proceedings of that file. I have confirmed that the file as it appears on page 8 of the report is what would be observable to counsel for the defense at that time upon successful completion of the downloading process.
Okay, so he would see this screen that I'm looking at now, the black one.
Yes, Your Honor.
Okay, so I won't know that this, how do I know that this black screen is that white screen that he downloaded? What's the name of this document I'm looking at?
This is the highlighted portion is the KBI lab results, Your Honor.
I know, but I'm saying, does this document with all these subcategories of what's on there have any kind of corresponding name to what I was looking at there a while ago on the white screen?
Yes, Your
when he
Honor.
was downloading it?
Yes, Your Honor. In the approximately a third of the way from the top, you will see a zip file entitled 23FG300002.
On the black screen?
Yes, Your Honor.
Okay, I see that.
And going back to page 1, the download single started includes a file name by the same name, 23FG300002.
So the black screen is what's contained in the first white line up there that says video 1 and 8.4 video 1. File name 819. Which one is it?
Right at the highlighted portion just above, Your Honor, file
Okay.
name 23FG300002.
All right, then what's all that other stuff that says it's been downloaded, all those other that aren't highlighted underneath the yellow?
Your Honor, those are download portions of the associated media with the case. The state's understanding is that is not currently an issue
Okay.
by counsel for the defense's motion, and so the state did not highlight that portion in its report.
All right. So, Mr. Hagan, did your office get or download 23 FG3 with all the zeros 2 in it?
Well, Your Honor, I'll have to get with my staff to see all that. What I can tell you is I know that I asked, did you get everything printed off? Whatever, she could not print that off. Okay, we knew that back in March. Okay, when we came to court in June, you ordered the DA to give it to me. How hard is it? It took him 2 seconds to give it to me at the last hearing on 11/1.
Well, I certainly agree with that, is because, you know, when it came down to it, Mr. Regier was able to do what I'd asked them to do, or to order them to do at every hearing. We did get it within a matter of minutes. I mean, that's
Right.
the problem I'm having, is why are we going through all of this right now? It's almost like, I almost feel like I'm just kind of fighting somebody that's being obstinate, saying, I'm not going to resend it because I already have. Now, maybe I'm getting the wrong impression, but
And Your Honor,
is that what it's come down to?
You
Your
ordered
Honor.
him twice, 6/17 and 8/19
Mhm.
in court, had to have a special court hearing, and you ordered it 2 times, and now he's trying to come up, well, we probably gave it to him electronically and he might have got it. No, I told you back in June I don't have it.
Okay.
Why are we fighting about that?
Yeah,
and Your Honor,
I'll let you finish your presentation, but I'll tell you right up front, I just don't understand. Maybe he had it buried in there somewhere, maybe he didn't. But would it have hurt to give it to him again? I mean, was this a matter of principle that somebody didn't want to give it to him because they already had? What's going on here? I just don't get it.
Your
Why
Honor,
my orders were ignored twice?
and if the court will permit me to continue, I will
Go
be able
ahead.
to answer that question. Your Honor, going on to page 2, the court will find 4 more highlighted entries indicating that counsel for the defense's office attempted to download the file on 2 additional occasions on March 12. And the court will also note that the download process was successful on that same day, also on 2 separate occasions. Those are highlighted portion entries 1, 2, 3, and 4.
Well, and again, I think that's consistent with defense counsel saying that they had tried to go back over it and find it. And that would be in March, and then he came in here in April and said, I'm still waiting on it.
And Your Honor, if I
Okay, go ahead.
Again, Your Honor, more of the same thing. Download more entries, download single started and download single successful on the same file. Throughout this entire ledger, the state has successfully tracked that counsel for the defense started download procedures and successfully completed downloading procedures on a total of 11 separate occasions, 3 times starting the procedure, 8 times starting the procedure, 3 times completing the procedure.
Okay, and you're saying that each thing that he tried to download there contained the black screen of documents.
Yes, Your Honor.
Okay.
And then finally, Your Honor, the court will note on this page 3 more purple indications.
What's the difference between purple and yellow indications?
Your Honor, the purple indications indicate where my office did re-grant the counsel for the defense access. The court will find, besides the first time that that access was re-granted back in March pursuant to page 1, this page, which I believe is page 4 of the report, will show 2 more indications where access was regranted to counsel for the defense on July 1st, 2024 at approximately 9:02 a.m., on July 1st, 2024 at approximately 9:03 a.m., and perhaps most recently on November 4th, 2024 at 8:15 a.m.
So you're saying that you in essence gave it to him every time he downloaded it
Yes, Your Honor.
because it was in this file that he says it wasn't?
Yes, Your Honor.
Okay.
On 11/1, he sent me the blood test results.
I got it by, well, I don't think I got the actual report, but I remember an email indicating that it had been sent. Maybe he sent it to me. I don't know, but
And he
remember-
sent it during the hearing. He took a break
Right.
from our hearing on 11/1 and sent it to me and then came back to court, and it took no time at all. So what is the reason that on 6/17, on 8/19, when I told him I didn't have it, couldn't he, that little 2-minute email that he sent to me, and you made an order, and I don't understand why he's not just doing what was ordered by the court, and here we are this months later because he wouldn't do it. I would like to have gotten this case over with.
Well, and that's what it boils down to, is maybe, I mean, let's say, all due respect, Mr. Hagan, let's say the defense attorney was totally incompetent and just couldn't read the file. He came to court, he said he wanted the blood draw report. I ordered it. Why didn't you just give it to him like you did the third order, the third time I ordered it in November? What was the reasoning for that, Mr. Regier? I mean, I get all this, what you're saying here, and maybe it was there and maybe it wasn't, and I'm not going to get into who is somebody pulling my leg, is somebody pulling tricks, or is this just some kind of honest clerical mistake of not knowing how to read a file or not sending it? What I just want to know, I want to keep this simple. Why did you not just send him the report? Like I said, has it gotten too complicated in your system to just do what you did the last time and send it? Do you have an answer for that, Mr. Regier?
Your Honor, what I can tell the court is that the court will note that when the court made its orders back in June, my office did reactivate the file. I have conferred with my colleagues regarding that, and I have confirmed that whenever an update entry is entered, an email gets sent out to counsel for the defense, notifying them that they have been regranted access.
So,
And Your Honor, one final point before the court makes its ruling. As previously referred to in the report, page 1 of the report does refer to multiple upload entries where the files were uploaded to the discovery file. If the court wishes, I am more than prepared to review all the other pages of the record, and the court will show that there have been no additional uploads since that initial upload.
no, I think I've seen enough to understand your position and what your evidence today shows. Mr. Hagan, you don't deny that your office has tried to upload these files or has uploaded these files.
My office has tried and has provided me everything that they could print. That's why on 6/17 and 19, and he says that these things now are all done. This is the computer telling you something, and I don't know whether, I don't have access, and I haven't looked through all this stuff or what printed everything, what he's looking at, because I can't even read this because it's too small for me.
Well, I'm struggling.
So, but all I can tell you is I don't understand why you gave him a court order on 6/17. And then if he says, well, we sent it to you this way, and then you say on 8/19, you say, can you just give him that? They don't do it. And then we come back on 11/1 and you don't even order it then, but goes back to his office and says he wants to get some information. And suddenly he can send it to me in 2 minutes. And he wasted 6 months of the court's time or continuing this out when they would have just done what I asked them. And then I had to have you order it because they didn't do what I asked them. And then you ordered it 2 times. And then on the third court date on 11/1, you don't order it because I have my motion. And now they suddenly provide it to me while he takes a break. So that's upsetting.
Right, Mr. Regier, we can take the screen down unless there's something else specifically you want me to see.
Not at this juncture, Your Honor, and with the court's leave, the state will stop sharing its screen.
Thank you. All right, it's your motion, Mr. Hagan. You've just kind of recapped and explained. If there's anything else you want to say before I make a decision, I'll give you your last, and then I will let Mr. Regier respond, and we'll go from, I'll make a decision from there.
That'd be fine, Your Honor. 22 KSA 2232 is statute. They need to have 180 days deadline. And I think we've passed that deadline. And there's exceptions, but I don't see an exception as material evidence unavailable. But here the evidence was clearly available and it was ordered by the court multiple times. And it was such an easy fix, it took him about minutes. So if the prosecutor can show me under the statute that he meets the exception to the rule, which is he has 180 days, and I don't believe there is any exception to it, Your Honor.
All right, Mr. Regier, final word?
Yes, Your Honor. The state's understanding is that when the court had ordered discovery, my office did take steps to comply with that. I think the record shows for itself in that regard.
In what way?
In that it shows that the discovery file was made available to the defense on multiple occasions. He initiated download procedures and successfully downloaded it on multiple occasions. The file was initially made available to counsel for the defense back in January when counsel raised concerns to my office that he did not have access to the discovery file. My office did reactivate it for his viewing on multiple occasions, once in March, 2 times in July, and 1 time in November. The state's position is that all discovery has been provided with counsel for the defense, and therefore he has been made aware of all that. While the state does understand that historically discovery procedures may have involved just sending out a note just saying something out by mail and then taking a handwritten note, my office has progressed far beyond that. The report clearly shows that besides being reactivated and emails being sent to counsel for the defense multiple times, counsel initiated the downloading procedures of discovery and successfully completed it also multiple times. So for that reason, the state respectfully advances that counsel has advanced a meritless claim, and therefore, for those reasons, the state is moving the court to deny the defendant's motion to dismiss.
So the county attorney's office has progressed far beyond sending out documents. They even went through a phase where they sent out information on discs. Why? Let me ask a question. What did the state bill you for the discovery, Mr. Hagan? If you have that available, or if Mr. Regier has that?
I don't have that available, Your Honor.
Mr. Regier, what would the state have charged to open this file and allow him to look at it?
Your Honor, in response to the court's inquiry, the state's believes the standard fee in these types of situations is $25.
All right, $25 to let them access and download your file, basically. Is that right?
That is my understanding, Your Honor.
All right, well, so you're not charging him per document or anything like that, like you would have done in that era before you progressed so far. So let's say you get an attorney, an old school attorney that hasn't progressed technologically as far as you have, but is still a darn good attorney. Is he going to be denied discovery because he doesn't know how to get into your system?
Your Honor, I have had the chance to previously communicate with my colleagues regarding this matter. Had counsel for the defense requested discovery in a specific format, my office certainly could have addressed that at the time, but it is the state's understanding that counsel for defense never requested discovery in a particularized format.
Well, maybe I'm just too unadvanced as well, but I thought when I ordered you to give it to him, you would give it to him and not just say, well, look it up on our file. I expected you to do like you did the last time and give him a copy of the document. But you're saying if they don't specifically ask for it in written form, you're not going to give it to them. Is that the way you usually proceed?
Your Honor, this is the exact same software that my office uses for every case. The court can speak to Mr. Andrews, Mr. Patterson, Mr. Page, whomever, and they will, and there's nothing special about this case. Again, the state's on the limited issue of whether or not discovery has been provided. The state maintains that discovery has been provided. Counsel for the defense never contacted my office for it in any specific format, only that it be provided. And for that reason, the state does maintain that discovery has been complied with in this matter.
Well, the attorneys you mentioned are all very local, but work probably the majority of their cases with your office. Mr. Hagan, I know I don't see nearly as often, but I don't think he should be handicapped or disadvantaged because he doesn't work with your office on a regular basis and use your system on a regular basis. Maybe he and his staff do, but whether you gave it to him and whether he downloaded it is not the primary concern the court has in this case. The primary concern I have is that I myself, as the court, specifically said, give him the report. Now, I'm not as new tech savvy as a lot of you are, and I'm used to the way the laws were written. Maybe they're not, I don't know how I haven't looked recently to see what they say about, can discovery be given the way your suggestion? Can it be given the way I'm suggesting? But when I say give it to him, I mean give it to him. And I feel like, again, maybe that was not the county attorney's office's intent, but I just felt like when I said give it to him, the response was, well, we already did, and we're not going to do it again. Now, from what your evidence shows today, maybe that wasn't your intent, but he paid for discovery. He's entitled to discovery. And he's asked for it for so long, so many times. I've ordered it so many times that I'm not going to accept the concept. I guess what you're saying basically is I should have gone in there and looked for it. if that's all the responsibility is to put it on a screen and say, well, go find it, go get it, then maybe that's what you expected me to do too when I told you to give it to him.
Your Honor, that is not the state's intention in advancing this argument.
Thank you. Well, I appreciate that. I hope it's not. And I take you at your word on that. But somehow there has been a real breakdown on this particular case of, you know, I can't believe we've gotten such an issue out of this that it's come to this point. I know when I say give somebody discovery, I mean physically give it to them. Don't just say, well, there's a website out there, go look for it. So for these reasons, because I feel like my orders were not enforced, I am going to grant the motion at this time. I'm not happy about it, and I don't, like I said, I don't know how we got here, but I know that I gave several orders over the course of months, and I don't feel like my orders were enforced. I don't think, if my orders had been enforced, I don't think we'd even be here today. There'd be no doubt he had the discovery. But when you start relying on computers exclusively and not even considering other options, even if they may seem archaic, I think we're going to, from time to time, run into a problem. And I don't like this, but I feel like it is appropriate based on the statutes and the facts presented that I am going to dismiss this. I particularly do not like this because of the charge involved. And I sure don't want the defendant to think he got away with something that he may or may not have. But voting under the influence, driving under the influence, is one of the most dangerous things that can happen. And I sure don't like this, but I feel like, again, based on the law and the facts, and it's the only right thing I can do. So that's my order. This case is dismissed.
And Your Honor,
Thank you.
Your Honor, if the court is dismissing this case under the circumstances, the state does reserve the right to refile at this time.
Well, I'll leave that decision to you. I'll leave any appeal decisions to you. Those are yours to make.
Thank you, Your Honor.
All right. Thank you, gentlemen.
Thank you, Your Honor.
In recess.
Thank you.